Please, Your Worship. I'd like to mention item number 15, Your Honor.
15.
Yes, Your Worship. The conducting counsel is out of the station due to some personal difficulties. And we have taken consent from the other parties also.
15.
Yes, Your Honor.
It's-
Item number 14 and 15, they are connected cases, Your Honor.
14 and 15.
Yes, Your Lordship.
Who is there? Godatari.
My lord,
We
in
have
item
taken
number,
consent from him, Your Lordship.
in item 14, I'm for the respondent number 4, private respondent. Both are connected case, my lord.
You are for
Respondent number 4 in item number 15.
your
KUA, appearing on behalf of Mr. K. Tama, the
will
conducting counsel.
dispose of this matter. Will dismiss the writ petition. What's there? Where's the petitioner? Where is the petitioner?
We have taken consent from him.
Forget about. Where's the petitioner? It's 2015 matter.
Yes, Your Lordship.
Both of you are for the respondents.
No, in item number 14, I'm for the respondent.
14.
Yes, in 14, I'm for the respondent, private respondent. Respondent number 4.
15.
In 15,
I'm for the respondent number 4 in the 15.
It's the same arises out of same
Yes.
issue.
my lord, kindly on the next occasion, counsel be present. Today, due to some personal difficulties, he is unable to present. My lord,
On the prayer of learned counsel for the respondents. List this matter after a week.
After 2 weeks, Your Lordship.
After 2 weeks.
obliged.
It is made clear, next para, it is made clear that no further adjournment shall be granted on the next 8 weeks. After 2 weeks, huh? List the matter after 2 weeks.
Deeply obliged.
May I, Your Lordship? Your Lordship, I beg to mention item number 13.
13 is also 2018 matter.
Yes, Your Lordship, but the conducting counsel is at 0 for some
Who is
medical purpose.
conducting counsel?
Subu Koyang, Your Lordship.
Who is for the petitioner?
D. Kamduk, sir. We have already taken consent from him. And both the parties have come to agreement that the matter may be fixed on the 23rd of this month.
On your convenient.
No, we have taken consent.
So do it without the permission. Decide yourself.
We have informed him, sir.
Yeah, if you have informed, you decide yourself. This after 6 weeks. On the prayer, on the joint prayer of learned counsel for the parties, Mr. E. Payeng and Mr. D. Kamduk. D. Kamduk,
Yes, Your Lordship.
who have agreed to pray for listing the matter after 6 weeks. List after 6 weeks.
Deeply obliged.
People are waiting for a job and it's been 2018. Yes, sir.
Yes, Your Lordship, on the last occasion, they produced one document saying that I have participated in the tender,
Yes.
and I was asked to explain regarding that. In that respect, Your Lordship, my submission is that it is they who need to explain in that matter, because my submission and my stand is still the same. I have not participated in the tender. So how they have obtained that paper, it is not only to them. Your Lordship will see if we look at the order submitted by them on the last occasion, they even my sign is not there. My sign is not there. Which means if they have issued this notice, they would have issued this notice to me.
This is LT Enterprises.
Yes, yes,
LT Enterprises.
yes.
You are not LT Enterprises.
Yes, Your Lordship. I'm for the petitioner, LD Enterprise.
Hmm?
Yes. I'm for the petitioner, which is LD Enterprise.
What is your, what is the name of your firm?
LT Enterprise, Your Lordship. LT Enterprise.
Then this not letter is to the proprietor of LT Enterprises.
Yes,
Are you a proprietor?
I am the power of attorney holder. The power of attorney holder.
Of LT.
Yes, yes, the plaintiff.
So if it is sent to the letter is sent to proprietor,
Yes.
according to you have no,
So I have not participated in this
you
tender.
have no connection.
So how they have obtained this paper is known only to them. Now, Your Lordship, if they,
See, you
Yes.
are a attorney holder. If your firm has participated,
yes,
who has authorized you,
yes.
are you not liable?
No, I'm submitting on behalf of the both plaintiff 1 and 2. Because one is the power of attorney holder and 2 is the LT Enterprise.
Yes, it has been sent to the proprietor of LT Enterprise.
Yes, but
LT
where-
Enterprise has participated in the
That is-
tender.
That is Your Lordship, what I'm submitting. The LT Enterprise has not participated. And if they say that they have sent this notice to the LT Enterprise, the proprietor, the sign of the proprietor has to be there, showing my receipt of this notice. They have to say that they have given this notice duly to me, and I have received this notice also.
Are you sure you have not
Yeah,
participated?
that is my contention. Yeah, I'm sure.
Suppose tomorrow if you find that you have participated, we'll call for the records.
Yes, Your Lordship. So therefore, my submission, Your Lordship, is that if they are saying that I have participated in the tender, let them file the proper documents with all the tender documents along with the minutes of the board proceeding, where they will be able to show the signature of the proprietor, containing all my signatures that I have
Forget
participated.
about the signature. Did you participate or
No,
not?
Your Lordship, I have not participated.
In that case, my lord, I may be allowed to furnish the records, original records of the LT Enterprise. So
Wait.
that it would reveal whether he has participated or not.
Yes, with all the proper records. Your Lordship.
You also file affidavit. You have received this.
This I haven't received. This I have received only on that day on the court.
Where we are giving you, we have asked him to furnish
Yes, yes,
you.
yes,
You
yes.
file an affidavit
Uh,
on that also,
Uh,
saying that I have not participated and where the firm has not participated in the tender.
Yes,
On ought,
yes.
file an affidavit.
Next Monday, my lord, I will bring the original records.
Yes.
Your Lordship, for filing affidavit, I need some
Huh?
time. For filing affidavit, I need some time.
When?
Fi-
For affidavit would not be required. My lord, may I please come
No,
to page
we
6.
would like to know.
My lord,
He's saying
Yes.
that he
My
has
lord-
not participated.
my lord may come to page 6, my lord, of the writ petition, para 4, my lord. He has already stated. Para 4, my lord, page 6.
Page 6.
Yes, para 4. Now. That the petitioners being registered contractor and well aware of the tender notification and its process, he had been waiting eagerly to participate in the tender process.
Para 6.
Para 4,
Where for yours?
page 6.
Page 6.
So, my lord, I may be directed to
That is
produce
his,
the original report.
that is his case only.
Yes, my lord.
You said he has participated and his bid has been rejected.
Yes, my lord.
No, I have not participated in this yet.
So, why, my lord, I may be directed to bring the original records, my lord. Everything will be clear, my lord.
In affidavit, Your Lordship.
You'll see the records
Original records, yes.
and
Because-
you file the affidavit.
Because in that case, Your Lordship.
Disowning this, clearly stating that you have not participated
Yes, yes.
in the tender in question.
Yes.
You file an affidavit, 2-page affidavit. Not Mr. K. Taja, learned counsel for the petitioner. This court on 06/09/2024 by taking serious exception to the serious view of the matter for separation of material facts. An opportunity was given to the learned counsel for the petitioners to explain as to why an exemplary cost should not be imposed on the petitioners. Mr. Today, Mr. K. Taja, learned counsel for the petitions, submitted that the letter dated 21/03/2024 addressed to the proprietor of petitioner number 2, namely MSLT Enterprises, comma, strenuously submitted that the respondent number 2 has never participated in the tender in question. List of Mr. In view of the categorical statement made by the learned counsel for the petitioners, comma, it is directed that the learned counsel for the petitioner, no, the petitioner, not learned counsel, the petitioners is directed to file an affidavit indicating the extent oblique the statements which the learned counsel for the petitioners has made before this court. List of next one. Having considered that the submissions, having taken note of the submissions of the learned counsel for the petitioners, comma, the respondents are the department are directed to produce the records, original records where the petitioner number 2 is stated to have original record of the NIT, a tender, original record of the NIT and tender where the petitioner number 2 is stated to have participated. List the matter on
After a week,
16 Monday.
after a week, Your Lordship. I also pray,
after a week.
yes, I also pray that Your Lordship, they may be directed to give me one copy of the tender documents so that I may peruse and give a
I'm
submission.
just indicating you,
Yes,
either of the two
because
are taking a
Your Lordship, if they're saying that I have participated in the tender,
taking a risk.
because yeah, that's Your Lordship. Now, if they submit the documents where my signature is there, I'll have to peruse whether it is my real signature or not. That I have to peruse. So,
It's okay. We'll not go into the technique. It's pure simple. We'll have to see whether you have participated in the tender or not. That will see.
Yes.
Once we find that you have participated in tender, will not hear you. You are taking your
there is one issue, Your
the
Lordship.
consequences will follow.
Yes, but
All right.
there is one issue, Your Lordship. The second issue is that I have to verify whether it is really me who has participated, or I have to ascertain.
Tomorrow, don't tell me. That's why you have heard the order. Will not accept any excuse that the petitioner number 1 has no
Not
knowledge.
participated.
Yes,
Yeah,
that
that
is why,
will not
Your
be-
Lordship, my
So I'm
son,
saying you are taking the risk.
Your Lordship, my prayer in that case is that I may be,
We'll see.
because
We'll
Your Lordship,
see. If necessary, obviously we'll punish.
it may be so that they have,
But you must know the form is in respond number 2.
Yes.
You must understand.
that is true, Your
It
Lordship.
is not the power of attorney. It is the form we'll see.
Yes,
Yes.
Your Lordship.
Whether you have represented, we have been authorized, will not accept. Next, last pair, huh? One last pair before listing, huh? It is made clear that no explanation of being not represented in the tender process on behalf of the respondent number two, which may be made by the respondent number, which shall be accepted in any circumstances.
Yes, Your Lordship, one submission kind. My
Have
submission.
you understood?
Yes, Your Lordship.
Tomorrow, if you say the petition number one, that I have no idea, I have no knowledge, because I have not been authorized to the authorized to represent in the tender on behalf of the respondent, petition number two will not accept
Yes,
that.
Your Lordship, my prayer, Your Lordship, is that it also has to be ascertained whether it is number two who has participated.
Will ascertain,
No.
that's why we call for the record.
Yes, Your Lordship. Now, since I'm
If it
saying,
is not, other way down.
yes, Your Lordship, simply showing few documents.
If it is not petition number two,
Yes,
we are
So-
not concerned about petition number one.
petition number two, Your Lordship. Now, if they're saying that I have participated in the tender, it has to contain all my original signature, Your Lordship. It has to be ascertained whether the signature is mine or just to favor the tender to some other person. They have engaged some other person. That also
We're
has-
not supposed to do that, but then we'll see. We're not supposed to do that. We'll see that. That's why we call for original record.
Yes,
Then,
on 16 March.
Think about it.
in
The order
last-
which this court has passed, it has some, it would have some consequence.
In the last line, I think respondent number one, two has been reflected instead of petitioner number two.
Your Lordship, in that case,
After 1 week,
no, after 2 weeks also. It's fine, 1 week, fine.
2 weeks, it's okay. 2 weeks.
2 weeks.
But-
What is the stage?
Stage one, 35% of the work has been completed.
Okay.
In the meanwhile, Your Lordship, I pray that the bill may not be paid
We have not issued a notice.
because they, fine, Your Lordship.
As
Yes.
on today, as per the records, you have participated.
I am just praying, Your Lordship, the copy may be furnished to me, Your Lordship.
Who-
The documents which they are going to submit before this court.
We'll see. If necessary, we'll give you the original records also.
Yes.
Yes, yes.
What is this? What is this?
Progress report.
Huh?
That is a progress report.
Give it back. Take it back.
May I place your lord?
Yes.
Lordship, the petitioner before your lordship is having only the limited seeking a direction of this novel code for issuance of the fresh NIT,
In respect of one package.
one package, madam.
How can we say so?
What happened in this case? The earlier NIT, altogether 9 packages of work
It's all
was
right.
advertised. And during the the pendency,
Are you alleging that without tender, without putting it to the tender,
madam,
they have siphoned off or
at this stage, it is also not, it is difficult to say, that part is because
we
the
cannot direct this, you tender this, you tender that.
once
Unless they decide.
amount is earmarked, sanctioned for the certain execution of the work. That has to be,
So what's the problem?
Yes, madam.
I'm verbally instructed that due to some problem is still hold for some time. They are going to,
You're going to,
yes.
you are going to do it.
Yes, the instruction is good.
We'll close this. I heard Mr. M. Kato, learned counsel for the petitioner. We'll close it. We'll record his submission. There's some certain
Well,
administrative issue.
Yes.
What is it? Administrative?
Yes, administrative issues.
So they will resolve it and issue tender.
Yes.
That's all.
That observation.
Otherwise, in petition itself is not within the.
In the earlier round of read petition also, the
Yeah.
different read petitioners. But by annexure, we have annexed wherein they have assured
By filing this, also heard Mr. G. Tarak, London Standing Counsel for the London Standing Counsel, RWD for all respondents. Next paragraph. Considering the having regard to the nature of the prayer and the statement made by the London Standing Counsel before this court. London statement made by the London Standing Counsel for RWD on instruction, before the court. This writ petition, I deem it appropriate to dispose of this writ petition at the motion stage itself. Motion stage itself. Next paragraph. By filing this application, the petitioner has sought for a direction to the respondent authorities, particularly respondent number 4, within bracket, executive engineer. Executive engineer what?
RWD,
the Daporizio division to issue a fresh NIT in respect of the work of construction of road from BRT road to Jibaying village in Upper Subansiri district. Please stop. Where does last order?
Madam, last order is page number, madam. 25, madam, annexure 4. Madam, this is in respect of other petitioner, madam. When this matter was moved before this noble court, they decided to, madam, initiate, madam, the press tender. Therefore, madam, this has been withdrawn.
You have withdrawn.
Yes, madam.
But grievances and petitioner, therein said petition difference. Their grievance was that due to positive time, they could not participate. So inter tender was put off and press tender was
But
issued.
then you have press.
Madam, page number
This is page
24,
25 or
20
24.
24, madam. First round of writ petition by different petitioner. It is submitted by the London Standing Council that the instruction has been received from the respondent number 4 that the press NIT will be floated and the petitioner may take part in the tender process.
Same party.
Same,
Not same
or admittedly,
Different.
madam, different party, madam.
Next paragraph. It is noticed that in earlier round of proceedings, being WPC 145 of 2024 and WPC 282 of 2020, some of the petitioners, some forms and then two forms, namely MSY Ringling Enterprises and MSTD Enterprises, have approached this court. That no adequate opportunity to participate in the tender process issued by the respondents. List, therefore, prayed for issuance of press tender, press NIT, so as to enable them to participate. The respondents on instruction in those writ petitions, in the above writ petitions, had submitted that press tender will be issued, and the petitioner may take part in the tender process. Accordingly, the above two writ petitions were disposed of on withdrawal
My lord, the second one is
Disposed
slight
of,
different, my lord, is because
was disposed of with a liberty to file a fresh petition if no such NIT is issued, is plotted. And the other writ petition was withdrawn. Mr. Next para. Mr. M. Kato, learned counsel for the petitioner, submits that despite such statements and assurances by the respondent authorities, the respondent authorities have only issued NIT for what?
for
Six packages
6 packages, my lord.
out of total 7 packages.
Out of 9, my lord.
Huh?
Out of 9, my lord. 2 has already been opened in as per the earlier NIT, and only this has been left out,
So we'll say out of 7, 6 have been plotted.
my lord.
Out of total 7 packages which were involved in the proceedings, in earlier proceedings. What is the last sentence? In the earlier proceedings. In the earlier proceedings. In the earlier proceedings, the respondent plotted only 6 packages out of total
My lord.
7 packages.
9 packages. Out of 9.
We'll say 7.
7.
9, 2 is already open and
Yes.
it has been open. Therefore, he submits that the respondents deserve to be directed to float the remaining 1 packages as the sanction has already been accorded for the said work.
Yeah.
As that of the other 6 works which have been already, which have been already plotted the tender. Mr. Next para. Mr. Jeetar, learned counsel, standing counsel, on instruction submits that due to administrative reasons, the tender in question, the 1 package, the one package out of 7 packages could not be put on NIT list. However, he submits that same shall be the tender will be issued. NIT will be issued in due course of the time as soon as the administrative issues is resolved. Issues are resolved. Mr. Having considered the submissions and on the categorical statement of the understanding counsel for the respondents, I deem it appropriate. I'm of the view that no useful purpose will be served in keeping this writ petition pending. Mr. Accordingly, the writ petition stands closed. Mr. It is needless to say that the respondents authorities shall issue tender in respect of the package. What is the name of the package?
My lord, construction of road from BRT road to
Issue
Jibaying village in Upper Sukhumvit.
tender in respect of the construction of road from BRTF
from BRTF Road to Jibaying Village in Upper Subansiri
Divine
district.
Village to Weber, Upper Siang district,
Upper Subansiri district.
after resolving the, after the resolution of the administrative issues, the respondents are stated to be facing, representatives.
No, please.
Deep level. Matlab, मैं afraid matlab some outer limit may be matlab given as because the other on the in the name of the exigencies matlab they will take another year. So therefore matlab the outer limit may be matlab as expected as possible. matlab.
Yes,
This court has also limited,
Matlab,
I mean,
deep level.
limited authority and scope to give all those future.
NIT initially was issued in the month of March. Matlab, everything has gone. Now it is September. And how
No,
long they-
nobody will stop you coming to this court
Madam.
again. Why liberty is
Madam.
different.
Deep level.
Item number 3. Are you in item number 3, Mr. Thorum? Well, it's your notice. You, it's up to 30th September.
30th
License is up to 30th September.
No, license,
You,
license is up to March 2015.
no, you'll be
25.
allowed to, agreement is up to, I mean, you have been allowed up to 30th September.
No, my lord. That is,
You
that
just
is
said
the, that
something
is the issue, my lord. Because they have arbitrarily decided that the tenure is till 30 September, man.
Hmm?
They have arbitrarily, man, unilaterally decided that it is till 30 September, man.
No, that we'll see.
30 September, after 30
30th September.
Yes,
Yes,
that
ma'am.
is the, as per the notice, it says so. But
It will be currency up to 30th September, according to their decision.
according to their decision.
Yes.
Yes.
So we'll ask them, you take instruction,
My lord,
how you can decide like that?
my lord, that is there, but just even,
Unless you show that the agreement gets,
my lord, I'll
left.
come, yes. I'll come up to all those details, my lord. There is a, subsequently, there's a standing order from the government that after the hospital, that the institution, medical institute is established, my lord, that no such private premises should be allowed within the premises. Madam, that subsequent the government has taken decision, madam.
decision.
Yes, my lord. And not only the petitioner, even so many other people who are the premises were running, they have
What
slowly
is
taken.
that decision?
My lord, that partner just now, I just I'll
In
come up
that
with
case, you file an affidavit,
my lord.
will state this, your decision.
Because my lord will see, my lord.
See,
Yes.
My lord.
by removing them to, I mean, have that kind of, it's a,
Yeah,
they are
but-
supplying medicines.
My
Are they
lord-
doing something other than the pharmacy? You are a supplier or you are?
I'm the
It is
retail
the-
outlet.
the retail running there within the premises.
24/7 service provider.
Yes, it is,
Only-
well, we just cannot disturb like this.
Only that, although that
Till returnable that.
my lord, but in this my lord, page 21,
Or
my
you
lord,
want to put someone
my lord.
in his place.
My lord, no. Nobody's putting there. Nobody's running. Nobody's allowed to. All the private, the premises will not be allowed. Slowly, so many earlier who were there running privately, they have been phased out. But slowly, they have. Now the petitioner is one of them. Man.
Yeah.
It's not again. We have given.
Others who are not concerned, they
My
are
lord.
not before us. We'll see, you file the affidavit, will stay in this till returnable date.
My lord.
Had Mr. Disoki learn counsel for the petitioner.
And my lord,
By
one thing,
filing this writ petition, petitioner has put to challenge the impute notice, put to challenge the notice dated 26/08/2024. Where is that notice?
Page 29, my lord. Annexure filing
29,
29. It was signed on 26/8, my lord.
issued by the director, Trims, Naharlagun.
The order speaks otherwise than the submissions advance, my lord.
Hmm?
This order, my lord, the notice, my lord,
Hmm.
it doesn't, my lord, go with the submissions made by my learned brother. My lord.
Yes, this is just a minutes of the meeting
It says that they will discontinue with the
Uh,
present
wait.
functioning form.
whereby it has been, it is, whereby it is decided to discontinue with the present functioning form of your SDC.
This is the Hospital Development Committee pharmacy.
No, your form,
Yes.
SDC.
My name is down below.
SDC.
HDC pharmacy is the pharmacy of the hospital itself. Hospital Development Committee
Yes, that's
pharmacy.
right. With the present, with the functioning, discontinue the functioning of the form of MSHDC run by the petitioner,
Yes, ma'am.
run by the petitioner, as the tenure would be expired on 30/09/2024. And to clear all dues, if any, by 30/09/2024. Issue notice returnable by 4 weeks,
3 weeks, sir.
3 weeks. As Mr. Tita, learned standing counsel. What is this? It's the trims.
Trims, my lord.
Do,
My lord, I'm representing Trims also.
okay, standing counsel for trims. Enters appearance on behalf of respondent number 1, 2, and 3. No formal notice need be served. However, extra copies will be furnished to the learned counsel for the petition during the course of the day. Next minute. Considering that the petitioner is running the form MSSDC pharmacy within the campus, within the campus of trims as a retail, what's retail?
Retail, yes, retail outlet of the
Retail,
selling of medicine.
retail outlet of the medicines, 24/7,
24/7.
27/7. It is provided that till the returnable date, the impute notice dated 12/08/2024 shall remain suspended. They shall not be given effect to, at least after 3 weeks. You have said something and they have taken decision, they have taken.
My
the
lord, that is
decision.
why they have maybe minute, the government decision has been brought in the, has been discussed in the minute. my lord.
No.
That maybe,
You can take a decision,
my lord, that
but
part.
it has to be in
And
the interest of public.
my lord, that is there. And then the MOU, fresh MOU is not there. And subsequently that extension, my lord.
We'll see. Yes,
My lord, this matter partially heard the last occasion.
you have withdrawn. This is a fresh petition.
Yes,
You have withdrawn it.
yes, due to some technical defect in my prayer person, so I was liberty to withdraw. I was granted withdraw and liberty to file a press. Accordingly, I filed this press petition. So my prayer before this honorable court is to admit the matter and issue notice to the other party, and meantime suspend the operation process of the NIT, impugned NIT. So on the
Heard
ground
Mr.
that,
T. Torup, learned counsel for the petitioner, who submits that his only prayer is to admit the petition and heard the matter. Admit the petition and issue notice to the respondents. That's all.
And in the meantime,
And in the
impugn
meantime-
NIT problem is state.
And in the meantime, state the what?
Impugn NIT dated
NIT
16/8,
dated
2024.
16. Where is that NIT?
NIT page number 34, page number 26. NIT
NIT
dated
dated
16/8/2024.
16/08/2024. Next para. However, this court, before admitting the petition, wish to look into the grievance raised by the petitioner. Please stop. Grievance raised by the petitioner as this court is of the view that the learned counsel for the petitioner would not object to such view of the court to look into that, to consider the grievances raised in the petition before the petition is admitted or issued, before the petition is admitted or issue notice to the respondents. Please. Stop. Next para. On bare perusal of the petition, it appears that the petitioner has sought for a direction to the respondent authorities to cancel the tender notice dated 16/08/2024 and to re-advertise, to issue fresh NIT by setting aside the NIT dated 16/08/20. No, sorry. To issue fresh NIT. And also to stay or suspend the NIT dated 16/08/2024. The contention of the learned counsel for the petitioner. No, the contention of the petitioner is that on the last date of submission of what is that? Site verification report. You have to submit the site verification report.
Yes, submitted a site verification.
On the last date of site verification report and the bank guarantee,
Along with bank.
bank guarantee in terms of the NIT dated 16/08/2024, comma.
My lord, bank
The
guarantee for
officer,
bid security.
the concerned officer who is responsible to receive the site verification report as well as the bank guarantee had closed the office. List of closed the office for which he was for which the petitioner was prevented from submitting the site verification report and the bank guarantee. List of. And further consideration. No further, no. relevant grounds have been raised by the learned counsel to the petitioner as to why the tender dated 1608/2024 should be cancelled or a fresh NIT should be NSC be issued. Mr. The statement, of course, the statement, obviously made under oath, normally, normally the court would take note of, however, without any other, without any substantiation, it is hard to take a view that the petitioner was in fact prevented from submitting the said verification report and bank guarantee on the date and time which the petitioner has stated to have visited the office for submission of the documents. Having considered above, but this court is not inclined to admit the writ petition. However, a notice may be issued to the respondents to respond to the contentions raised by the petitioner. Accordingly, issue notice returnable by 4 weeks.
Otherwise, my lord, if my small one contention, my lord, could be recorded, my lord. At page 34, my lord.
Yes.
Serial number 4, physical submission of original bid security. If my lord has seen page 34,
Yes.
original bid security,
Yes.
serial number 4, / POA, etc. That is 26/8/2024 up to 12 hours, my lord. And my lord will kindly come to page 22. It talks about POA also, my lord.
Power of attorney.
Yes, my lord. My lord will kindly come to page.
It's okay,
20.
we're not passing any interim order.
Yes, my lord. The
Is not it?
POA, he still does not have the POA. At page 22 is the,
Have you heard what I have passed?
My lord, here, clause chapter 4.413 CPW manual. So where in case of
See, that will be contradictory. One thing you are saying that you visited the office.
yes,
Your trust is to submit all this,
yes,
but then the officer were absent
yes,
and in the office was closed.
yes.
That's your trust.
In
Now
my-
you cannot take another contrary view that no 14 days time was not given.
No,
All
that
this
is
thing.
one of my ground.
That can
I have
either of
two
the
ground.
either of the two.
Yes,
That's a contradictory. Either you have to say NIT doesn't provide a adequate opportunity time of 14 days or 20 days, whatever. Right? Or else you have submitted and you went to the office to submit the other documents.
so here, my lord, page number 22 itself, this is my application, submit to the authority to issue site verification certificate. As per the SBD, I visited the PO and verified the all site project, and I asking for the site verification report. It was not accepted. Page number 22 is my application.
Before issuance,
23.
before issuance, before that, huh? You right? You add one more line. the issue raised, the the primary contention of the petitioner, if it is accepted, also, comma, in my view, it would be a purely disputed question of facts. Not in my way. Privacy, it would be a purely disputed question of facts. Then you- Issue notice returnable 4 weeks, 3 weeks or 4 weeks,
3 weeks.
3 weeks. Since Mr. N. Ratan, London Additional Advocate General, and Mr. T. Tagum,
Okay, Mr.
for respond number 5,
They're not in married party.
have entered appearance. No, in that case, you just said not Tagum, huh? London Additional Advocate General enters appearance and accepts a notice on behalf of the respondents. The no formal notice in how extra copy so and so, huh? And next. We'll write in the caveat. Caveat is there. Caveat is there. List after 3 weeks. That's all.
Obligation.
You just read in caveat, huh? Had Mr. T. Tagum so and so. Caveat is 10 teachers. You plead him.
My lord, as of now, he is not a
He has filed a caveat.
successful bidder.
Have you received the caveat?
No. As of now, he is not successful bidder. How
You
he
give-
can be a party?
You give him a
The
copy.
under technical bid only, financial
He'll
bid
give
is
you
not
ca-
open.
We have discharged the caveat. We'll give you a copy. So you think about it.
My lord, he is not a cannot be a party because what is not allotted to them. How he can be a party? in
You
this
just
case?
furnish the copy of the caveat. I have discharged the caveat. Whatever you want to do it, to the best of your understanding.
All right.
What is this?
My lord, is a writ petition. I'm the section officer of RGO, working from last 20 years as a section officer. And here, impugned interview notice, page number 25, issued by the respondent authority to conduct a written test among the 7 section officer.
What the rule says?
So as per guideline, Central Ministry of Educations and UGC guidelines, where the Central University have doesn't RR rule approved, the interview cannot be conducted, and promotion this interview also cannot be conducted. So this in violation of the UGC guideline and Ministry of Education, the respondent authority of Rajiv Gandhi University conducting press advertise and this promotional advertise. This in violation of the order. So my lord, kindly come to the order and what the
Yes.
guideline says.
UGC guidelines?
Yes.
UGC guidelines?
Yes.
Yes, so
Page number 92.
92.
Yes. This is a letter dated 15 November 2017.
It's okay.
Here,
you
page
just
number
go.
96. Kindly operated portion, page number 96.
96.
Yes. This letter is issued by the UGC to the all universities, all central universities. Here, page number 96, clause 4, Roman 4, deputy register.
As
As
per
per
MRC,
MR instruction, the post of deputy register is to be filled up by 75% direct recruitment and 25% by promotion. However, university in violation of the instruction of the MHRD prescribed 50% of direct recruitment and 50% of promotion. Further, provision of the higher grade pay of rupees 10,000 has also been prescribed, which is not permissible as per UGC/Government of India rule.
Yes.
5, assistant register. Similarly, for the post of assistant register, the higher grade pay of 7600 under CAS has also been provided, which is not permissible as per rules of the UGC and Government of India rules. The above are example only. How a university has made a lot of irregularity in each of the posts while making the recruitment rules. The university has also not met the preamble for the recruitment rules as per requirement of the Department of Personnel Training norms. Being serious irregularities made in the recruitment rules, it would be more appropriate that university may be advised to immediately withdraw the recruitment rules and keep in abeyance the any recruitment and promotion on the basis of these recruitment rules. If the university had made any promotion under the provision of the recruitment rule in violation of the Government of India rules, it may be withdrawn immediately. This is issued on 2017. Thereafter, on the next page, page number 97, here, another direction issued by the UGC, 18th November 2021.
UGC or MHRD?
UGC,
This is a letter by the MHRD.
University Grad Commission,
Huh?
Ministry of Government of.
This is a letter by whom? Okay, UGC.
Yes.
Yes.
So another direction, page number 97.
Where's the relevant?
Page number 97,
Yes.
18 October 2021. The subject to the
Frame
registrar
the
all
gather
universities.
recruitment rules of the non-teaching post in central university regarding. It's okay. Where
relevant
do you have
person-
the recruitment rule?
Recruitment rule they have submitted to the UGC,
Hmm.
but UGC did not accept the recruitment rule submitted by the RGO, and thereby instruction has been framed. The instruction in this page, paragraph, same page number
In view of the
97,
understanding
operation
directed
portion.
from the generation may frame the cadre recruitment should non-teaching post vision for. Which one? This
Yeah,
university may
Clause
not
one,
advertise,
university-
fill up the any of the non-teaching unless and until CRR of the non-teaching post is part of ordinance approved by me.
on age per clause 1, the university cannot conduct any interview or promotional. And clause 4 says that grade C of the staff of the university has given to the private university.
You are seeking a promotion from advertisement
Section
is for
officer.
filling up of assistant registrar.
Yes, assistant registrar. Here,
The
in
work
violation
related
of
to transport
the
is
direction
really-
issued by the UGC.
Which
Uh,
clause you are relying? One, clause one,
yes, clause 1.
page 97.
Yes. The university cannot advertise unless and until CRR of the non-post age of part of.
What
the
is
ordinance
CRR?
approved. CRR 2022, I have annexed the CRR.
Unless and until CRR, where it is?
Page number 28.
28.
This is a draft case statement rule 2022. By the RGO, annexure 4.
So this has been accepted.
Not has been accepted. So, my lord, another RGU and UGC communication letter. Page number 100. Here clearly mentioned, the university does not have a approved RR rules. Page number 99 here directed to the university to submit the RR. So page number 100 is a reply submitted by the university.
100.
Yes, page number 100. Modality for implementation of the model RR. So here, whether name of the university, Rajiv Gandhi University, whether university has framed the CRR of non-teaching staff, no. The answer, no. The next, if yes, whether CRR been approved by competent authority as per provision contained in the Acts Statute of the university. The answer, due to non-finalization of the rationalization of cadre structure and designation, pay scale, etc. of non-teaching employees, the university is unable to prepare the CRR. Here clearly written that the university is still not prepared the CRR due to technical reasons. And thereafter, page number 101, here university constitute a team member, 2 members from the faculty to represent on behalf of RGU before the UGC. Namely, Gomar Basar, Assistant Professor Exam. Number 2, Solong Sonam, System Analysis. These 2 members has been nominated. And among the 2 members, only 1 member, Solong Sonam, represented before the UGC. And page number 102. After attending the convention with the UGC, the report, this is report submitted by the representative Solong Sonam. Their report, A, clause A, 1A, the university, the undersecretary has specifically mentioned that model CRRA sent by the Ministry of Education is not enforceable, as it is just a model, repeat model, which is a reference for all the universities which have not yet drafted and any approved RRC. Universities having a draft and empowered CRR may continue to go along ahead with the process requirement rules, the PCH per rule. This is those who have approved CRC, they can continue. C, while drafting the CRC, it is to be ensured by the university that there is no major deviation from the rules already under applicable in university who have the
So
approved
this
CRC.
CRR has not been approved.
Yes,
as on-
right now our university.
Where is the NIT? Advertisement, sorry.
Yes. 25,
Advertisement. Advertisement is where?
page number 25.
25.
Yes. Page number 25, this is notification. It is hereby informed to eligible candidate under zone of the consideration for the post of assistant registrar, upper division clerk and laboratory assistant, that in continuation to exam notification that 12 July 2024, the whole written test will be as per schedule given below.
13
This is
September.
advertised, this is notification.
You are
and-
concerned about the assistant registrar.
Yes, page number 26 is a notice
Or
called
Mr.
letter issued to me.
Yes.
My lord, in the year 2015, cadre recruitment rule has been framed by the university. Thereafter, what happened? There is an objection from the UGC in the year 2017 that there is some irregularities in there, so recruitment rules should be framed. Accordingly, UGC has sent thereafter in the year 2022, Rajiv Gandhi University has framed a recruitment rule, and
Yes.
the Executive Council of the university has approved.
Come.
And they have discussed with the central UGC undersecretary, and they have directed that as per cadre recruitment rule framed by the Rajiv Gandhi University, appointment has to be done. Accordingly, from 2023, as per this cadre recruitment rule, Rajiv Gandhi University are conducting the examination to the non-teaching staffs. And this is the cadre recruitment rule.
It has been approved.
No, approved means there is a direction from the undersecretary that as per this cadre recruitment rule, till approval, examination can be conducted. Accordingly, everything has been done as per. And this has been approved by the
executive council is only member of the university only.
Just give me the relevant one. This is the relevant.
Executive Council is the highest body of the university.
Placement of the draft cadre recruitment for non-teaching posts is part of the ordinance that is based on the model recruitment approved by the EC noted that the ordinance is based on the letters of the recruitment.
They only draft proposal from the university side. And this was replied by the UGC Annexure 13. Earlier I have read. On what ground that proposal has not been considered? Ground is clearly given. And they are
Where it says that till it is approved by the UGC.
My lord, first they have a frame a model cadre recruitment rule by the UGC. Thereafter, as per the model cadre recruitment rule, university has to frame a cadre recruitment rule. That is called recruitment rule. Accordingly, university has framed this recruitment rule. And this has to be sent to the UGC and Ministry of Education. And after that, it should be published in official gazette. Before doing that, so many posts are vacant lying in the university. Accordingly, the instruction has been given by the undersecretary of the.
Give that. What is that?
It is in the writ petition.
Where?
The last page. 102.
102. Yes.
It is down below B. B.
University having a draft and approved CRL may continue to go ahead with the process recruitment as per the rule.
They have discussed with the undersecretary, madam.
Huh?
They have discussed with the undersecretary. Last year also, as per this CRR, examination has been conducted for deputy registrar. And there is no any objection from any side.
This is the
So
report.
many recruitment has been done. This is settled rule. This is settled rule.
What is settled rule?
Settled rule means last time also we have conducted examination of deputy registrar. This is assistant registrar.
Where it is settled?
Deputy registrar.
Deputy registrar has
Yes.
settled that.
Last year, in the year 2023, we have conducted examination of deputy registrar. And this is a assistant registrar.
Anybody objected to it?
No, nobody is objected.
Okay,
No.
so therefore it said settled.
No, as for cadre recruitment rule, it is settled. That finally it should be approved by the UGC. Till that examination is to be conducted, man.
Yes, my lord, this CRR proposal is to be made by the university.
That's okay.
And
That
same
has
to
been
be
done.
sent to the
That has
UGC
been
for
done.
approval.
Draft has been sent.
Yes, draft has been
Draft has
sent.
been, so it says, clause B in the page 102, cadre recruitment rule. Universities having a draft and approved CRR may continue to go ahead with the process as per the rule.
My lord, here CRR is still not approved.
Draft,
Still not approved. Draft the proposal. Is proposal on
see, law is well settled when rule is not finalized.
my lord,
The recruitment can
Yes.
be based on the draft rules.
as per the instruction issued in the year 2017, here clearly indicate the proposal sent by university. not
How many
accepted.
posts of assistant register?
Only one post.
Will
And-
will stay this
No.
till only in respect of the assistant register? You are seeking a
No,
promotion.
my lord,
Yes. And moreover, my lord, here government of India clearly
Heard Mr. T.
directed-
Toruk, learned counsel for the petitioner. By filing this writ petition, the petitioner has put to challenge the advertisement by notification dated 28/08/2024. By which the respondent issued by the registrar, Rajiv Gandhi University. Issued by the registrar, Rajiv Gandhi University. Whereby the eligible candidates under zone of consideration for the post of assistant registrar. No, for different posts. Consideration for the post of different posts, including the assistant registrar, have been published. The next contention of the petitioner is that the cadre recruitment rule within bracket CRR has not been finalized, and has not been finalized by the university. Please stop. By an order dated 18/10/2021, the Undersecretary, UGC has directed the register all central universities, inter alia, that university may not advertise fill up any post of non-teaching post unless and until CRR of the non-teaching post as a part of the ordinance is approved by the Ministry of Education. Any further amendment in CRR, if any, also needs the approval of Ministry of Education, Government of India. Mr. Toru, learned counsel, while referring to the RTI, reply, referring to the reply by the Rajiv Gandhi University under RTI Act, submits that the authorities has clearly replied that no CRR has been framed for non-teaching staff. And the draft CRR is yet to be approved by the UGC. Next paragraph. Mr. What is to be recorded? Your name?
T Gati.
T Gadi or
Yes.
something else? Titi Gadi.
No, T Gati.
I'm purposefully asking you.
T Gati.
T
Upper
Gati.
Gati. Yes.
Again, you come back.
No.
I've seen somewhere Titi Gadi.
Yes,
something-
TL.
TL.
Yes.
That's why I'm asking. Which one I have to
T Gati.
T Gati.
No, it is appropriate.
Learned Standing Council for the University. Well, relying on this is not relevant. We'll rely on the submitted by one Sri Mr. One Mr. Solung Sanam, system analyst of the university,
Yes.
submits that the UGC has allowed the university to continue to go ahead with the process of recruitment of DPC as per the rule on the basis of as per the university, as per the rules to the university having draft rules. Therefore, he submits that the impute notification, advertisement issued for filling up the different posts, including the post of assistant registrar, in terms of the draft recruitment CRR, which is pending approval by the UGC. As all the posts, including the assistant registrar, have been lying vacant in the university. Issue notice returnable by 4 weeks. Mr. Tigadi, since Mr. Tigadi, London Council, Standing Council, has entered appearance and accepted notice on behalf of all the respondents.
Yes.
No formal notice need be served. Our executive business furnished to the London Council. Next one. Hard on interim prayer. What is to be done? What is your interim prayer?
To stay the examination going to be conducted on 13 September 2024.
We're just
Truly.
staying because there's a letter that should not advertise as per the UGC
Yes.
of 2021.
Yes.
But law is very clear. Even if it's recruitment is not finalized, rule is finalized, draft recruitment rule can be.
My lord, one more ground here, central government issued a notification that again, when the organization head is about to retirement, within few minutes, few months before, such advertisement selection cannot be done. Page number 73, clearly instructed.
What does it mean?
Central government, government of India, under secretary, issued a notification for the university that those who university for head of the department, the BC, at the verge of retirement, such requirement or selection cannot be done.
Where it is?
Page number 73. This notification.
No, this advertisement issued by the registrar, not by the VC.
Now, retirement is the last retirement. The BC is retired on 3rd October 2024. Only few days left. Here, instruction for head chairman of autonomous body initiating to make selection at least 2 months before including their tenure. Sir, I am directed to bring to your notice that general convention in the government that the heads/chairman of various organizations do not conduct interview.
So
selection
registrar
2
is
months before.
going to retire.
Yes.
Registrar.
Yes. No. BC.
The advertisement by the registrar.
No, here register also. The approval, this notification, this interview is conducted on approval
Anyway.
of the BC.
He heard on the interim prayer, huh? Considering that, huh? The university. What is the by order that is changed, huh? Next para. The university, the UGC by letter dated 18/10/2021. No, that I've already dictated. Last.
Ministry of Human Resource Development, Department of Education, not instead of UGC.
No, that no. Last after the issuance of notice. Last line. Then thereafter. By the order that by letter dated 18/10/2021. Inter alia, has directed that the university may not advertise fill up any of the non-teaching posts unless and until, CRR of the non-teaching post as a part of the ordinances approved by the Ministry of Education, till the returnable date. The advertisement for filling up of advertisement dated 28/1/08/2024 in respect of filling up of assistant register still remains suspended. We're staying the assistant register only. Just after 4 weeks.
Highly obvious.
Yes,
Ma'am. Malad, please come to, it starts from 2013, Malad. May I please come to page,
normal, put it in normal. Yes,
page 57. Malad.
put it in not to. No. 20, put it in 24 or 25. 24, 25. Yes,
Yes, Malad. Now, the facts of the case starts from 2013. Malad. On 30 May 2013, Malad, the DGP, Malad, has issued an advertisement for lady constable, for recruitment of lady constable in total 180 posts. Page 57. Malad.
yes.
Yes, 57, Malad.
What do we want?
Now, there is some interesting facts, Malad.
Yes,
Yes, ma'am. This advertisement, lady constable, 144 APST, general 36, total 180 posts, ma'am. Now, in that regard, madam, page 61, ma'am. Total 137 lady constable were appointed, page 61, ma'am. Subsequently, page 65, ma'am, on 20 May 2014, 13 lady constable were appointed. Again, 30 May 2014, 1 lady constable appointed. And again, on 16 July 2015, 1 lady constable was appointed. Ma'am.
you are challenging the cabinet meeting,
Yes,
cabinet minutes,
yes,
cabinet decision.
yes, madam.
Which
Because
was-
there has been
which
some
was-
wrong interpretation of
Which
the
was
judgment of-
taken in pursuant to the order of this court.
Yes, my lord.
Then
Ye-
how can
yes.
you challenge that?
My lord, there was total 180 vacancy, my lord,
It's all right. There is a direction of this court. Right?
which was recalled. My lord. That's why, my lord, may I please come to judgment of this honorable court, my lord.
Yes, where it was recorded.
Directly, my lord.
Where
Yes,
it
my lord.
is?
Page 89, my lord. The relevant
89.
paragraph. Or relevant page 89. There was 2 repetition filed.
WPC 148,
Where is the,
68, it starts from page 68, my judgment. In WPC 49 of
the effects
2007.
of the action of Mr. resorting to preparation of mandates from state level, district level on the ground of different districts having different dialects can be established. There was no material to indicate this. Therefore, the view taken with the influence in the consideration only applies to the present case as well. Under this reform, I don't find the requirement to develop in other districts. In my concern, we have succeeded in making out the case for interpreting religious order. While taking such a report is not have since been joined, respective places. Therefore, it will not be progressive in the intersection for the same time, but the selection. Yes, this
Yes,
is page 90.
Yes, my lord. In this writ petition, my lord, the direction was given to the respondents to adjust the writ petitioners. Writ petitioner, my lord. Now what happened, my lord? Subsequently, review petition was filed by the statement, page 91.
Yes, where is the,
In the writ petition, my lord, 148 of 2015, my direction was given to adjust the writ petitioner, my lord, against the available vacancies. my lord.
cannot prevail now. The auto employment will happen now. Prepare a mail list of medical center and the percentage. The 180 ladies and appointed order is reason this subnotice, although they fail to compensate. We consider the appointment in terms of the. It's okay.
Yes, my lord.
Heard Mr. B. Pitcher, Land Council for the petitioners.
Petitioners,
How many?
2.
Petitioners? By filing this petition, the petitioners have challenged the cabinet decision dated 12/10/2022, and also the appointment order dated 21/06/2021. Are they party here?
Yes, my lord, private responsible there.
Appointment orders that is so and so of the 37 lady constables
Yes, my lord.
who are added at who have been added at respondent number 1, 2,
My lord, it would be from
all but 37.
6. my lord. It would be from 6 to, or 37. my lord. 6 to 42.
6 to 40.
42.
42. Yes. Mr. The contention of the learned counsel for the petitioner is that the respondent authorities have misinterpreted the
Review
judgment and the order passed in the review petition, huh?
Yes, my lord.
Misinterpreted.
Yes, my lord.
Passed in, what is that?
Page 91. my lord. The review judgment, my lord.
Passed in review petition
Yes. my lord. 91.
number 6 of 2019. By this court on
6 and 7.
05/02/2022. Huh?
6, 2019 and 7, 2000. 2 review petition was filed.
6 and 7,
Yes.
2009. Huh? Review petitions, issue notice. Returnable by 4 weeks. As Mr. S. Tapit, learned counsel for the learned senior government advocate, enters appearance on behalf of so and so, huh? All respondents.
1 to 5.
1 to 5.
1 to 5, no formal notice to now. I will extra copy this so and so. Then counsel for the petitioners to take steps for service of notice upon response 6 to 42.
Yes,
Within 3 days,
but this 1 week.
within 3 days from today, least after 4 weeks.
Problem.
May I please also? Malad, this matter is, Malad, we are challenging the ejectment order, Malad.
Where is this?
In this matter, what happened is that in
Yes,
2021, there was a notice order from the,
can I take up this matter?
yes, Malad.
Notice was issued in on
On 13/3/2024, 5 months.
If,
where it is?
Malad, it start from,
Page 41, my lord, your lordship.
Okay,
page 40, Malad.
40 or 41?
40, Malad. 40 until. Now, this was issued to around many villages. Malad, in fact, the petitioner, they are settled in 1966. And now that area is recognized as a village by the government notification.
Well, say we'll consider, it's been, the notice is for within 15 days from the date of issue of the notice, spelling which,
Yes,
13/3.
Yes, my lord. But then they, chances that they may try to evict, my lord.
Let them respond because 15 days is already over.
Yes, my lord. Similar, my lord, similar matters your lordship has considered, and just take to your lordship has considered this is similar matter, my lord.
Which one?
What the petitioner from the villages called Mutka and Mudongkong, and similar matters was over Sampai too. You also was pleased to pass for the status quo in that matter. We have enforced in this matter. This is similar matter, my lord.
Passed by this court,
Yes, my lord. My lord, it's in page, my lord.
where it is?
Page 86. Your lordship has thought that. Page 86. They are from the other village, and the petitioner who are in this red petition 144, my lord, in page 86, my lord.
Same,
Same, my lord.
same orders.
Same order, my lord. So I will also pray that same order might be possible. Status quo might be maintained. Because both area is a recognized village, my lord. I'll just take to the
This is
village.
also for, this is also for oil drill.
Oil drilling, same place, my lord. Same area. Total area is 7.11 hectares. My lord, and there are also NHRC order also there. My lord saying that they should not be forcefully evicted. Page 60, my lord, I will just take to page 60.
What to do? Same order,
Yes, my lord. I pray that.
hard mister. We'll say status quo.
That is the problem, my lord, because,
Same eviction notice.
yes, my lord. that
You,
I
you
could-
immediately file the response. We'll
But-
dispose it off.
But when you see them and who is before your lordship,
Yeah.
Deuri and Chakmas, they are quite different, my lord.
What is to do?
Your lordship knows about the Chakmas, my
No
lord.
discrimination, even to the
But-
foreigners.
Here, my lord, what they are asking for the land compensation. And we say this is a reserve for us. Actually, they should ask for my resettlement rehabilitation.
Have you
Yes,
filed response in the other writ petition? Previous, the
Well,
earlier writ
in
petition?
that petition, my brother
You
represented this.
take care of the things to be,
But,
need not have the stay order to remain
Well,
for indefinite period. We'll dispose of the matter.
my lord. Now, what is worrying for you, my
Since
lord?
this similar order has been, I mean, in the
My
similar.
lord,
matter,
rightly, wrongly, your lordship
Yes.
passed the order. I'm not harping on
it's
that.
difficult.
But only problem is, my lord, Now this Dayum Reserve Forest was notified in 1962 and their settlement is from 1970, Malan, which is much later, Malan.
1966.
Yes.
Heard Mr. Esmo, learned counsel for the petitioners. How many petitioners?
8 petitions, my lord.
Huh?
8.
Next, by filing this petition, the petitioner has put to challenge the impugn order dated, put to challenge the eviction notice. Is it notice or what?
Yes, my lord. Ejectment notice, my lord.
Eviction notice.
Ejectment notice under Arunachal Pradesh Forest ejectment of unauthorized person from the Reserve Forest Rule 2013.
Page 40, huh? Eviction notice dated 13/03/2024. Whereby the petitioners have been. You just say individual eviction notice, huh? Put to challenge the individual eviction notice. Not individual, eviction notice dated so and so, issued individually to the petitioners by the divisional forest officer. Under Arunachal Pradesh Forest within bracket, ejectment of unauthorized persons from reserve forest bracket close rules 213 and section 72 within bracket small c bracket close of Assam Forest Regulation Act of 1989, whereby the petitioners have been directed to vacate the enclosed reserve forest land within 15 days from the date of issue of the notice, failing which they will be evicted from the reserve forest area and the cultivation area will be confiscated or demolished. It is also provided that no compensation for loss of such property will be given to unauthorized occupants. Issue notice returnable by four weeks. Occupied since 1970 or 66?
66, my lord.
66.
Yes.
As per your lordship order, it says, Malan, 1970.
70, yeah.
66, my lord.
66
Yes,
in this petition.
yes, my lord.
Page 688, huh?
No, Malan, that cannot be because
This is
That-
contention.
that's the concept.
this is
They will
our-
dump somewhere in 69, not prior to that, Malan.
Huh? Page 88, we just recorded. Then since Mr. Arichnabab, learned additional advocate general has entered appearance and accepted notice on behalf of the insurer, our actual officer. Next, you don't write all these things. It's contention 66, page 88. Then write, considering that this code has provided to maintain status quo by the parties in the similar petition being WPC 144, public 2024, comma. It is provided that the till returnable that parties to maintain status quo.
As
I'm
on
just
that-
granting because
Age on that, Malan, age on that.
Right.
Your lordship
Age on-
clearly mentioned,
age on-
age on that. If they are
Age on-
evicted, then they are evicted.
as on today, to maintain status quo
No, they are not evicted.
as on today.
Age on today. If you are not evicted, well and good.
Apply.
Then, Malan, there are private respondents also there, Malan.
Private respondent, yes.
Okay, then you write.
Respond number
Learned counsel for the district is for service of notice upon respondent number 4 and 5.
yes, my lord. IOC.
4 and 5. Barrister was to ensure within 2 days.
Obliged.
Yes.
4 and 5, yes.
Hmm.
Obliged.
List this matter before any other appropriate bench without me. Item 8. The earlier one will be after 4 weeks. List after 4 weeks. Huh? List the matter after 4 weeks earlier.
Item number 9, it's here. Government had filed reply. That's
Yes.
to me. So I need to file rejoinder to it.
Why?
So I have not even received the copy.
Huh?
So I will have to go through it.
Okay. You want to reply?
Yes.
File reply.
Yes.
Mr. DK, the learned counsel for the petitioner. Press for an is granted 3 weeks time to file reply.
And Your
Reply-
Lordship, I am appearing for the respondent number 5. Today I am
Right.
filing my wakalatnama.
You record your name.
Obliged.
Mr. Aris Nawab, learned additional advocate general. It appears for the state. Mr. So and so, learned counsel
Jacob.
for enters appearance on behalf of respondent number 5.
5.
List after 3 weeks.
Sorry, my slight correction, my lord, we have not filed the affidavit.
Then
In fact, my lord, we have asked the department to
Yes.
send the officer posturing the affidavit.
He communicated me. He communicated that we had
you
filed.
have received the.
No.
Then
He
when
just,
when you have not received, how can you pray for that?
he just communicated to
You
me.
just delete it.
Okay.
Or Mr. DK, they will learn counsel for you. Then in that case, Mr. Aris Nawab, learned additional advocate general. Praise for it is grant 3 weeks time to file affidavit.
Obliged.
Then you read, Mr. So-and-so enters appearance on behalf of respondent 5. List after 3 weeks.
Obliged.
May it please, your lords.
Yes,
My lord, we have filed an interlocutory application, my lord, under order 17, rule 1, my lord, seeking 15 days more time, my lord, to file the written statement. There are various allegations that will require some time to procure the relevant documents.
yes.
15 more days, almost 15.
No objection. Okay, with the
Your Lordship, I'm appearing for respondent number 3 and I
Three.
have filed my wakalatnama today.
Who is 3?
Je-
Who is respondent number?
In main petition, Jeremiah Krong.
Huh?
Jeremiah Krong, she's a candidate.
Candidate.
Yes. In the main petition.
Will main petition will say, aye, huh?
Yes.
Or Mr. Deepang, learned counsel for the applicant oblique respondent number 1.
One.
And also had Mr. A. Tatak, learned counsel for the opposite party public petitioner. Expert. This is an application under order
Order 17, rule
17
1.
rule 1 of CPC. 1908, praying for adjournment of the connected election petition for 15 days for filing written statement. We'll just not record it. If he doesn't have any objection, we'll just say. Where is the ground that is,
My lord,
where is the ground for seeking time?
paragraph 3, my lord. Three and four. 3 and 4.
And then in the next, Mr. A. Tatak, land counsel to the opposite party oblique petitioner has no objection to the application for present application seeking time to file written statement. Next paragraph. Having considered the grounds for seeking time to file written statement and the objection not being raised by the opposite party petitioner, comma, I deem it appropriate to allow this application. Accordingly, the applicant, public the respond number 1 is granted 15 days time to file written statement. The written the IA is still disposed of. And other IA,
Lordship, the district election officer, they filed an IA for
we issued notice on the.
release of electronic.
This was
vote.
already issued.
No, we have already directed.
Lordship,
So,
in the,
May I pray that Lordship, I may be granted few more days to file my objection with regards to this interlocutory appeals, 145.
Lordship, in 145, notice was already issued.
Huh.
And as per the order, I was supposed to take steps upon respondent number 4.
Okay.
So since respondent number 4 is already appearing
In IA.
in IA 45,
Yeah,
145.
45, we have issued a notice.
Yes, your Lordship.
Only notice.
Only
We have
notice.
not allowed the IA
Not allowed the IA,
Okay.
but I was supposed
in
to
IA
take steps.
45. This IA
145.
160 is disposed of, huh? 145, Mr. In IA 145, Mr. A. Tata London counsel to the opposite party petitioner. Press for it is granted 15 days time to file objection. List of MS
Pulia Pulu.
enters appearance on behalf of respondent number 4
For in
Ah.
this IA, and I have received a copy.
and list after 15 days.
Lordship, and for respondent number 2, Lordship.
2 and 4. Record their name. Whatever you want to do, what do you want?
Lordship, I may also be allowed to file a written statement by the next date, Lordship.
No, that we'll see.
In IA, I have no objection, Lordship.
We'll see. Okay.
Actually, as per CPG, they have to file this application.
Then list after 15 days. Then in election main petition, heard Mr. So-and-so, so-and-so. And Mr. Deepangin for respondent number 1.
In election petition, your Lordship, I'm appearing for R4, returning officer.
R4, 2, 3, you record the name. Enters appearance.
I'm appearing
with
for
change.
3.
Whatever you want to do it, do it. All right,
Oh, please.
find out. Okay. Lordship, list after, list on, will give a fixed date.
25th.
25th of
25th is,
Of
will not be
September.
15 days, I believe. 26th then, Lordship.
26.
26th.
09.
26th. Yes, June.
September.
September.
Yes.
26th.
I don't know if 15 days you there.
15 days would be over on 25th. So 26th, the matter may be listed on 26th.
Anyway, 26, list the matter on 26. This court is trying, should be disposed of within six months. You support?
The manner in which the allegations are made and that the reply will come, I think it will take time because there will be lots of witnesses.
6 months is a
I know,
long
I
time.
understand. But
As of now,
ultimately, they will have to
as of
adduce
now,
evidence first.
determined to dispose of within 6 months.
We'll see, madam.
Yes.
I'm in receipt of the counter of respondent number 2.
Yes, why?
I might not be filing the reply. Can it be listed on 24th of September?
No, affidavit has not been filed.
Filed.
Yes, we
Counter
have
has
filed,
filed.
Your Lordship.
But
By
the
respondent two.
office note says, shows the contrary.
I will-
Anyway,
I will
heard
receive.
Mr. So-and-so, case action, counsel for the petitioner. Office note dated 13/07/24 reflects that no affidavit. In who is respondent number 2?
DGP. That will
Huh?
cover all. There are 3 respondents. DGP is the respondent number 2.
So
that will cover all.
So your affidavit will cover the respondent number 2 also?
Yes, Your Lordship.
So that reflects that the affidavit of opposition has not been filed on behalf of respondent number 2. Mr. Y. Ram, London District Council submits that since the affidavit has been filed on behalf of the state, no separate affidavit is required on behalf of the petition number, the respondent number 2. Mr. K. Saxena, London Council for the petitioner, press for him, granted 3 weeks time to
No,
file.
Lordship, a specific date, 24 of September, because my promotion has been held up, it is kept in seal cover. And
You are asking for time to file.
no, Lordship, on 24th of September, specific date. Specific date, 24 September.
Granted 2 weeks time to file affidavit.
Humble prayer, Lordship,
affidavit
because-
reply. Huh?
Because Mr. Tiwari will be appearing in this case, 24 is coming, that's why.
List the matter on 24.
24 September.
09.
Same 12 also, same 12. Same.
Same order.
Kind of.
Same order. Okay.